All right, so this week we're going to talk about federalism and specifically American federalism because it is different from other federal systems out there. We were one of the first countries to sort of adopt this scheme to our government. Other countries have since adopted it. It works well for large mass decentralized countries, but other countries look different than what our American federalism looks like. Before we jump into federalism, I do want to cover different types of government systems. So this is not in your textbook. There is a video link at the bottom if you want to look at more information. I will warn you in advance, the video link is definitely trying to convey a certain message or convince people of a certain message, but there's a lot of good information in the video, particularly on how different types of governments affect personal liberty. And so the definitions you see on this actually comes from Charles Wolfe, in 1978. Again, I think it's a very good explanation or definition of the different types. So most of what we're talking about in the US is this difference between democracy and republic, and you'll hear it maybe sometimes in public debates, right? The US system is a republic, which means rule by law or limited government. So our Constitution is really our founding document. It limits what the masses or the public, the majority, can do, which is democracy. Democracy is ruled by the majority, at least a pure democracy. So we don't have any pure democracies in the US, even at the state level. At the local level, you actually can. There are some very small towns that do run some pure democracies, but those are the rare and the exceptions. But there are a lot of democratic principles. This, again, majority rule, that's how Congress runs for the most part. A lot of elements within government use democratic elements or principles, again, limited by the rule of law or the constitutions. So it is good to kind of keep this in mind and keep these definitions and maybe why some things are set up the way they are. It is, again, kind of based on these sort of notions of the difference between democracy and a republic. And again, states tend to be a little more democratic in their type of government, not in their political parties, because they are a little more directly linked to the people. And then local governments even more so because they're, again, even more so directly linked to the people. So as we're talking about thinking of government, it's good to remember that a republic both derives its power from its citizens. So a republic is literally a rule by the people is another definition that can be used, but it also places limits. So it places limits on both the government and direct involvement by the people. So both the government and the people are placed within limits in a republic. Again, a difference between a democracy. And the real reasons for this is kind of just to ensure that there's a balance, that the minorities' rights are not going to be overridden by majorities' decisions, especially when decisions by large masses can often be made under emotional reasons or for other reasons and not always at the best interest of everyone. So we do have some ability to direct our government and to influence our government, but it's not always a direct participation. It's more of an indirect participation at most levels of government. And so this takes us to the concept of federalism. As James Madison kind of states in Federalist 10, the federal constitution forms a happy combination between these two extremes. Unitary systems where the central government or the national government has full control over everything, and a confederate, which we tried at the very beginning of ours, which allows power to be very decentralized and given out. So the states actually had more power than the central government, which didn't work because our national government or central government didn't have enough power. So in their second attempt at forming a government, they kind of drew to this idea of federalism that they saw as sort of balancing between. So we end up with this combined system where we have both a national government and state governments that share responsibility and also share power. So that means that both our national and our regional governments share power and they're considered independent equals. So the states haven't given up all of their power when they decided to join the United States of America, right? When they united together to form this new country, the states retained power and sovereignty. So what this means is that as we begin to look at the different powers, we have exclusive powers of the national government. So there's some things that only the national government can do, and those usually are tied to either issues involving multiple states or international issues. And then we have powers that are exclusive to the states. So there are some things that powers and rights that have been reserved to the states, and the states have full autonomy and the national government can't tell them what to do. So education is one of these, although we'll talk a little bit about that. And then there's shared powers. So there are some powers that both the state and the national government have. One of those is the power to tax. Hence, we have to pay both state and federal taxes. So hopefully when I mentioned states are sovereign, the Supremacy Clause might have come to mind, and like, how does that all work? So we do have the Supremacy Clause, which basically says the U.S. Constitution and laws passed by Congress override the state constitutions and state laws. The one caveat is to this is when it is within the power of the national governments. So whatever they're doing has to be within the power of the national government, in which case then it would supersede states, both their constitutions and their laws. So even laws passed by Congress can supersede state constitutions within that. The U.S. Constitution, because of how it's written, is always going to supersede those. And then I also want to highlight the guarantee clause. So this is in Article 4. And basically, it guarantees to the states that we will have a Republican form of government. And basically what this means is that we aren't going to kind of shift to a more democratic rule where they have the mass voting, right? So if we went to a popular vote for the president, for example, that would shift us away from a Republican form of government because you now have a mass voting as opposed to each state sort of being able to have a say. So instead, while the presidential election is a national election, we have the Electoral College, which means that this presidential candidates have to win in individual states and then collect those individual states in order to win the actual election. So it's also relevant to talk about two of the clauses that pertain directly to the states in the U.S. Constitution. So one is the full faith and credit clause, which basically means that states have to abide by or accept things from one state to another. So if you get your driver's license in one state, you can drive through other states in order to get to wherever your destination is without having to, stop and check in or do something. The other states will recognize your license given by your state. Now, if you move to a different state, that's something different. But traveling from state to state, if you get married in one state, right, you move to a new state, you don't have to re-get married or reapply or do a new marriage license. The marriage is recognized because it was recognized in the other state. So that's the full faith and credit clause. The privileges and immunity clause also means that people can't be treated differently from one state to another. So if a citizen from one state is in another state, they can't be treated lesser than the citizens of that state. So you have to treat citizens of other states equally. All right, so now we'll kind of jump back into this federalism. So there's three different types of federalism mentioned in your book, but I think these two are the most defined and the easiest to sort of understand. So dual federalism, which is what we had for about the first 100 years or so of the country, and it's that layered cake approach, which means that it's very clear, like, right, this area is covered by the federal government, this is by the states, these things are covered by the federal, these things are by the state. So it's kind of clear who's doing what. After the Civil War, we kind of get more of what's known as the cooperative federalism. And you kind of get the marble cake, and particularly after the World Wars, it even gets more so into this regard, where you see the national government getting more involved in things that had traditionally been more in line with the states. You also see the states becoming more involved in different areas as well. Really what this means is government in general really grew and expanded, and therefore, they're touching on more areas and they're overlapping, which means it's not often really easy to know which government is doing what, and they can often both have their hands in the pot. So the other thing the book kind of talks about is sort of this shifting of power, right, between the national and the states. And we see this happen most often in something fairly major. As I mentioned, we see the shift between the marble cake from the layered cake to the marbled cake after the Civil War, the Industrial Revolution, and then really the Great Depression and the World Wars. They really sort of shift things. And really, so there's historical impacts that has caused these shifts in federalism and the shift between powers and who's doing what. And they're usually, I will say though, they're usually almost always economical. That's usually the answer for most things when it comes to government and power. The people who have the money, the people who have scenes, those with power, right? It's the economics, it's the money that's really kind of driving forces in most of the change that takes place and happens. And again, shifting that power back and forth between the national and the state governments. So the balance of power is also decided by the federal government, and the three branches of government have varying levels of how much they can determine the balance of power between the national and the state governments. The president retains quite a bit of this, and basically it's determining how they decide to run the agencies, or whether or not they decide they want the federal national agencies to retain power and really kind of dictate or give very clear, very precise directions to the states and to the local agencies, or if they give more they do more delegation. So the national government will set sort of high level regulations or kind of standards for what they want, and then they allow the states to sort of figure out what works within the state in order to, as long as they meet whatever that high level qualification is. So those are the two different types of sort of power that the president has over agencies, and different philosophies they might have on this national versus state power. And then part of that is also how they determine grants. So again, whether grants are given out with very specific criteria, so a grant is given to the state and they're told exactly what they have to do with it, or if what's known as block grants are given out, and that means the states are given sort of this larger sum of money. It's usually tied to a specific area, but they're not necessarily told exactly what they have to do with it. So COVID's a great example of this. COVID funds were given out, especially early on. It was kind of said very specifically what had to be done. So COVID funds were given to higher education, and they said it had to go directly to students who were in need. Now the schools and the state had to figure out what that meant and how they determined the need, but basically it had to go to students. The federal government is giving out about 3 rounds of COVID funding to higher education. And by the third funding, they were a little more loose and basically just said that it had just to be spent on something related to the higher education, to education that was affected by or in some way maybe hurt by the pandemic. And so then states had a lot more flexibility. A lot of states used some of that funding for technology, which was needed during COVID, right? So a lot of things went online. Students didn't have technology. Schools didn't have the technology. So they were able to then sort of decide how and where they spent that money, as opposed to the earlier funds, which were very specific and were given very specific rules about what they could do with it. Congress has the least amount of influence, and it's really because you have so many different members, right? So out there, especially in the House of Representatives, their states are different, they're different, and so really their biggest impact on federalism, or the shift of power, is when they pass any laws that sort of take what is assumed to be powers of the state or rights of the states, and the states believe that they're overstepping those boundaries. Which leads us to the third branch of government, which probably has had the most influence on this balance of power between the states and the national government, and that's the Supreme Court, who basically decides if Congress has overstepped their bounds. So McCulloch versus Maryland is the first key case where this sort of comes up and gets established, that the Supreme Court's going to basically be the deciders on where exactly the balance of power, right? Who is right and who is wrong. So make sure you understand the case. There's a couple links at the bottom. But basically what this comes down to is the Maryland was trying to tax the National Bank of the U.S. And of course, national government says, hey, you can't do this because it basically is going to make the bank go bankrupt. And so it really comes down to whether or not establishing a national bank was necessary for Congress to carry out its power to tax. And we'll talk a little bit more about this in a minute, but it's talking about the necessary and proper clause, right? So does Congress basically have the power to create a bank, is what the court is answering. So in this case, it's decided by the Supreme Court Justice John Marshall, who also does Marbury versus Madison, which we'll talk about in next week. But so he is very much a federalist. He's in favor of expanding the power of the national government, making sure the national government is strong and it's not going to collapse. And so he errs on all of his cases on the side of the national government. And so he finds that creating a bank is necessary. It is within the power of the national government, and therefore the state is not allowed to tax the bank. All right, so and if you watch the link on the previous video, it kind of explains John Marshall's life and sort of his philosophies. And one of the things in that video that I really like is this notion that I think is a little difficult for us to understand, but it's a really good one, especially when we're looking at anything historical with the government and trying to understand this difference in the relationship between the state and the national government. But before the U.S. Civil War, citizens would often describe themselves by their state. So for the most part, they would say, I'm a citizen of Virginia, Pennsylvania, New York, not I'm a citizen of the United States. It's not till after the Civil War that people start to use that I'm a citizen of the United States first, and then would say what state they're from. So John Marshall is one of the exceptions to this rule, hence sort of his philosophy and views. But it was a shift in thinking in the United States that took place during the Civil War, right? When we're fighting to preserve the nation and preserve the United States, it becomes something that people then begin to take on as an identity. All right, so also relevant, and this actually gets us down in during the Civil War, one of the Civil War amendments are also very relevant to this discussion of balance of power between the states and the national government, and that's the 14th Amendment. So this is the first time we have in the Constitution anything that states no state. So the Bill of Rights begins no, the Congress shall not, but the 14th Amendment begins no state shall. And what ends up happening with the 14th Amendment is that it then begins to be used by the national government to limit what the states are able to do. And it's done in such a way to protect the rights of citizens within that state, but it expands the right of the national government to now dictate to states what they can and they cannot do. Basically what types of laws they can pass and within that, right? So they now have to meet this due process clause and equal protection clause that ties into that. And it ties in, so what the Supreme Court ends up doing is tying in these clauses to the Bill of Rights, again, which begins, Congress shall pass no law. So what that means is that the Bill of Rights actually becomes incorporated into the 14th Amendment. So this is done by the U.S. Supreme Court on a case-by-case basis. So they didn't just say all of the rights within the Bill of Rights apply to the states, because they don't. Some of the rights do not. Some of them have never gone before the Supreme Court in order to be heard or asked about, such as the Third Amendment. And then some have gone before the Supreme Court, and they have said, no, it does not apply to the states. And there's very few of those. Like the First Amendment. So all of the 5 rights in the First Amendment, the freedom of speech, freedom of the press, freedom of religion, those all apply to the states via the 14th Amendment, the Due Process and Equal Protection Clause. So I really like this cartoon because it demonstrates it very well. So prior to the 14th Amendment, only the national government had to abide by the Bill of Rights. The states, for the most part, had their own Bill of Rights within them, but they were varied and different, and how they applied them could be different, right? Because they're individual to each state. After the 14th Amendment, the Bill of Rights, for the most part, now applies to the state governments as well, which also means consistency across states as far as what rights you have. It's not as varied as it was prior to the 14th Amendment. All right, so I'm talking a lot about the power of the states and the national government, but we should definitely want to talk about the fact that there are different types of power, and 2 in particular. So there's different terms, especially for the first one: enumerated, explicit, expressed. It is helpful if they all begin with E's. But these are the powers given directly by the Constitution. So that means you can read the Constitution and you can see the power clearly laid out and clearly given there. And then there's implied powers. And these are powers that are just assumed to be given in order to carry out enumerated powers. So the 10th Amendment is an implied power for the states. If hopefully you know what the 10th Amendment is, but if you don't, basically it says all power not given to the national government is reserved to the states. So that would be an implied power, right? There's no powers, there's no rights specifically listed in the 10th Amendment for the states. It just says they retain any powers not given to the national government. So this becomes an implied power that the states then argue that whether or not they have a certain power within the 10th Amendment. The national government, specifically Congress, also has implied powers. These are in Article 1, Section 8. Again, these are very broad general statements, and that's how they become implied powers. So 2 of the main ones are the General Welfare Clause. So, right, Congress has the right to maintain the general welfare. Well, what does general welfare mean? What falls within that? That's what then becomes up for debate, right? And then there becomes debate between Congress and the states over whether general welfare fits within what the national government can do, or is that a right reserved to the states? And again, the Supreme Court becomes the decider in that balance of power. And then there's the necessary and proper clause, and this is the one that was being used in McCulloch versus Maryland. So when it comes to the necessary and proper clause, it really comes to the definition of what is necessary. So Federalists such as Alexander Hamilton and John Marshall, who we talked about earlier in McCulloch versus Maryland, they basically say that necessary just means anything that's convenient or appropriate. So basically, Congress can do or pass laws that make carrying out their expressed powers more convenient or they're appropriate for carrying them out. Those who maybe want there are some that wanted a more stringent definition, Thomas Jefferson being one of those, and a lot of those individuals who argued on the side of the anti-federalists, kind of against the U.S. Constitution at the beginning. They thought that necessary should mean something that is essential or indispensable, which basically means that Congress cannot carry out its duties without this additional power or right, right? So they have to have this additional power right in order to carry out their expressed power. Otherwise, it is retained by the states. And then lastly, we have the Commerce Clause. This is a little more direct in some ways, but it is also can be vague. So what fits into it? So Congress has the power to regulate interstate commerce. So, right, commerce between the states. But what exactly does that mean? Where does that, where does the line cross between interstate and intrastate commerce? And so I have a few things listed on here that kind of shows you what the Supreme Court has decided that Congress may regulate versus what they may not regulate. And so all three of these clauses, as well as the 10th Amendment, how you interpret them, how you view them, is going to decide on where you think a balance of power between the states versus the national government lies. And you'll kind of keep this in mind as you are working on your applying the topic this week. So you're going to be looking at some of these for your applying the topic, but I just kind of want to highlight them. So this is some of the current items, right? So you think after 200 and almost 50 years, right, that we'd have this sort of established power of what's a national power versus what's a state, but we still have several areas where it's very unclear, and it can be argued either way. So you can kind of decide on these. So that's one of the things you can look at, right? You can look at these different ones and sort of decide where do you think the power should reside, at the national versus the state government. And again, so these are just some of the hot issues, some of the main ones that are kind of coming up right now in different debates. So I just want to finish with sort of this last idea that to keep this in mind. You might think of areas, and we'll talk about different areas where the states actually still retain power. They have the explicit power over things, and education is one of those. It's a great example of this. Education is a power reserved to the states. The states retain the power to determine education standards. However, if you accept federal funding, you are now under the obligation, in order to receive that federal funding, to abide by their mandates and restrictions and regulations. So No Child Left Behind, Common Core, these are federal mandated education things. The states didn't have to follow them if they didn't want to accept the federal funding. So the only way to not do those is to not accept the federal funding. But what we'll see as we start to get into some of these topics, especially later in the semester, states have become more and more reliant on federal funds, which means states have become more and more restricted by what the federal government tells them that they have to do. And again, this is another piece to keep in mind as you're maybe thinking through some of those. So highway funding is one that is on that list on the previous slide, that kind of is really tied more to this funding idea than it is to actually the national government being able to claim that they have a power or a right over it. Right, so you can kind of think about it and decide for yourself, right? When it comes to especially these implied powers, where do you think that power lies?